Heather, go ahead.
All right. Well, thank you very much, Chairman and members of the committee, for having me here today. My name is Heather Cessna, and I am the Executive Director of the State Board of Indigent Defense Services. And I'm here today to give you a update on the status of public defense in Kansas. I know there's a few of you who are on the Criminal Justice Reform Commission, so some of this may seem kind of repetitive if you've already heard that presentation. But I did want to go into a little bit of detail because we have some significant problems that we are attempting to deal with in the public defense system here in Kansas, and we definitely have some budget issues that are coming up. And I think it helps to have some background information on all of that before you have to eventually vote on that. So moving forward, really the issues that I want to talk to you about today are high caseloads, our lack of pay parity and other compensation issues, and our lack of sufficient staffing in our public defender system and our assigned counsel program, and our lack of other basic infrastructure resources. All of these problems have unfortunately been exacerbated by COVID-19, and we've gotten to a place where unfortunately our public defense system is very much in crisis. To start off with, obviously, this committee has more background information than some on how our public defense system works. Obviously, you're entitled to the right to counsel under the Sixth Amendment and Gideon versus Wainwright if you're charged with a crime. What a lot of people don't realize is that the state of Kansas does provide for that constitutional right to counsel through the Board of Indigent Defense Services, and that 85% of adult felony cases in Kansas require appointed counsel. And that's one of the reasons why this is particularly important, because BIDS's problems are not just BIDS's problems. They are problems that have a huge impact on the criminal legal system.
Okay, hold on 1 second. It's not streaming?
I don't have a picture.
Oh, the content. I see that on my screen now. It says committee room is starting to share content.
You want me to hold on while you look at it for a second?
I can hear the testimony. I just can't see the room's up at the top of the main part is still starting to share content box, but we can hear.
Okay, perfect. Give us just a second. We'll get this fixed up.
Okay.
I think we're fixed from my end, Mr. Chairman.
I think we're still waiting to get her presentation to pop up. So give us just another minute or two. It was attached to, let me find it. Oh, hold on a second. Maybe not. You're correct. You're correct. So we'll make sure we get that ordered out. How about, I mean, you're welcome to talk through the PowerPoint on your screen, and then we'll make sure we get it distributed to the distribution list. Okay.
All right. Well, technical difficulties aside, you know, it wouldn't be 2021 or 2020 without technical difficulties. So we will go ahead and pick up where I left off. And since I'm going through and talking this through and you're not seeing it on your screens, I mean, definitely let me know if you have questions or if you want me to slow down a little bit. So as I was saying, one of the reasons why business problems is not just business problems is because 85% of the adult felony criminal cases in Kansas require appointed counsel. And so that's, you know, that has ripple effects throughout the entire criminal legal system if the public defenders and the public defense is not working properly. Just to give you a little background information on how public defender offices and our assigned counsel programs work. And we do have two sides to our program. We have our public defenders and we have our assigned counsel. Public defenders are state employees. They're hired by their chief public defenders. They're subject to a lot more direct oversight during the course of their cases because they are directly employed by the board. There are only 11 trial public defender offices in the state of Kansas, and total, and this includes trial public defenders, appellate defenders, and our capital public defenders, we only have 123.5 public defender positions in Kansas. And that's compared to 355 criminal prosecutors throughout the state of Kansas. Our assigned counsel program works differently from our public defenders in that our assigned counsel are generally private attorneys who volunteer on the panels to accept cases at low-paying rates or take low-paying contracts as part of that. They are typically solo firms or small practitioners, and because they're private lawyers taking cases, they're not subject to the same kind of direct oversight that our public defenders are. We approve their experts and we approve their vouchers and things when they submit them after their representation is over, but we don't have like day-to-day control over their representation as they're going through and handling cases. Our breakdown of our cases in 2020 and our breakdown of cases in 2020 was a little bit lower than normal, in part because of the last quarter fall off in cases as a result of the court system shutting down due to COVID-19. But we had just over 26,000 cases. About 44% of those were handled by our public defenders, and 56% of those were handled by our assigned counsel. Consistently, our public defenders are more economical than our assigned counsel program. In fiscal year 2020, our assigned counsel cost $175 more per case than if a public defender had handled the same case. So one of the problems that we've had is obviously our caseloads. So I wanted to talk about that a little bit. Our most immediate problem is our caseloads, and that is based partially on the fact that there are national standards from about 50 years ago that indicate that you are, as a defense attorney, not supposed to have more than 150 felonies per year per attorney. And there's a reason for that, because high caseloads have a number of problems associated with them. Everything from driving, you know, a problem with our recruitment and our retention. It deters people from coming public defenders or joining our assigned counsel program if we have too many cases. And it also drives our mission-driven employees away. One of the things that we found out when we did an employee survey last year was that while 81% of our employees reported that they came to work in public defense because they believe in what we do, 55% of those people indicated they'd also considered leaving the agency within the last year, in part due to the high caseloads and pay parity issues. High caseloads are also an effectiveness issue. Obviously, if you have too many cases and too many clients, you don't have enough hours in the day to do all the things you need to do to represent somebody effectively. And that's also one of the reasons why high caseloads are an ethical issue. The Kansas Rules of Professional Conduct for Attorneys, Rule 1.3 on diligence, comment 1 explicitly says that a lawyer's workload should be controlled so that each matter can be handled adequately. And there are a number of down-the-line consequences that come up with not being able to effectively handle your cases because of high caseloads. And those include viable and effective assistance of counsel claims, wrongful conviction lawsuits, legal malpractice claims, ethics investigations, and the potential for protracted and expensive litigation over the constitutional adequacy of the entire public defense system as a whole. But of course, most importantly for us, is our inability to provide our core agency mission, which is to give our clients a zealous and effective criminal defense. So our caseloads in Kansas in fiscal year 2020. One of the things that you will find in your PowerPoint presentation, once you get a copy of that PDF, is a breakdown of our trial offices' average public defender caseloads for 2020. And that chart shows you each of the trial offices that we have along with what their average cases were for 2020. In fiscal year 2020, out of our 11 trial offices, only 3 were able to come in just at or under that 150 felony per year per attorney absolute maximum caseload. Every other office was substantially above that. And even the offices that were able to come in at or under that 150 felony threshold had to pay a price to do so. So for one of the things that you'll see on that chart is that our 3rd Judicial District Public Defender, which is the public defender here in Topeka, they were able to come in right at 150, average 150 cases per attorney per year. But they were only able to do so because they also refused cases for 172 days of the fiscal year, which was 47% of the year. And that's due because of the high number of cases that they had and the lack of attorneys to staff those cases. Our Sedgwick County Public Defender, in contrast to that, they were averaging 278 cases per attorney per year, which is substantially higher than the 150 caseload cap. They were only closed for 15% of the year. And unsurprisingly, they also had the most chronic turnover problems of all of our trial offices in 2020, in part because the caseloads were overwhelming. Our average for our agency of trial public defenders, excuse me, was that they were carrying 205 cases per attorney per year in 2020, or 55 cases above the absolute maximum. So then the question is, when you're looking at this, what does that actually mean? I mean, if you're saying 205 cases, that sounds like a lot of cases, but what does that actually mean? Well, when you break it down, that ultimately ends up meaning that each attorney has only 10 hours per year to work each of those 205 cases. That's unacceptable under any measure of professional standards. For a perspective, a recent study of Louisiana public defender caseloads found that a lawyer should spend approximately 22 hours working on low-level felony cases for reasonably effective assistance of counsel. And the same study found that for higher sentence without parole cases, an attorney should do approximately 200 hours on those felony cases for reasonably effective assistance of counsel. We're averaging 10 hours per case per attorney on everything from low-level felonies up to off-grid life sentences. Obviously, that's highly problematic. And the reality is that that's based on a 40-hour work week. I mean, the reality is that in order to cope with that, our attorneys are working evenings and weekends constantly, which is what partially burns them out and causes these turnover issues that we've been experiencing. You have to remember that we don't have any control over the number of cases that come into our system. And this is part of the problem. Our caseloads are entirely controlled by the legislature, who decides what to criminalize and what to make felonies, and the prosecutors, who have prosecutorial discretion over the number of cases to charge and which cases to divert and which cases to include or charges to include in any given case, and the number of crimes that occur. I mean, we don't have a way to stop those cases from coming into our system. So it's just a question of where do they go. When we don't have enough public defenders to handle those cases then get put off to our assigned counsel program. But our assigned counsel program also has its issues. Right now, we're paying our assigned counsel $80 an hour for the cases that they're working. A 2017 KBA study determined that the average per hour rate of private counsel in Kansas was around $225 per hour, which means that that $80 per hour statutory rate is about 64% below the going market rate for private counsel. And the problem with that is obviously it becomes problematic for us to be able to recruit people to our panels at that rate, or to recruit people who are experienced enough to be able to handle the high-level cases that they end up getting. It also makes it hard to, well, the low statutory rate inadvertently incentivizes private counsel to take higher caseloads in order to cover their overhead costs and to make ends meet. And it's also been statistically shown to incentivize private counsel to go to trial less frequently, because that means that their low rate of pay means that pleas are essentially paid better for the time spent on them than jury trials are. Our pay parity issues, unfortunately, are not solely the problem of our assigned counsel. They are also part of our public defender system as well. National standards call for a pay parity of resources between prosecutors and public defenders, but prosecutors are constantly paid significantly higher than our public defender counterparts, which creates a problem for us because we consistently lose people from the public defender system to go become prosecutors because they can do the same work for substantially higher pay. And what we did was we conducted a study of some of the differences in prosecutor and public defender pay salaries in Kansas. What we found was that while prosecutors and public defenders often start off on relatively equal grounds when they're brand new and fresh out of school, pay-wise, as soon as they start getting any level of experience, their salaries for prosecutors diverge significantly. For example, our top paid public defenders in the public defense system are paid anywhere from 23 to 50% less than their prosecutor counterparts in the same jurisdictions. And for example, this is not just a problem with our prosecutors either. This is also a problem with parity of resources between other defense programs. For example, our top paid public defenders in the agency with 25 to 35 years of defense experience and as head supervisors of their individual offices make a salary comparable to what an assistant federal defender with 0 to 3 years of experience can make one block down the street from our public defender's office here in Topeka. So it's really no wonder that we have both a significant recruitment and retention issue in the agency. If our caseloads weren't enough to deter people from working for us, certainly our pay issues would. We also lack a lot of other resources. We don't have our sufficient staffing for our public defender's offices. We also lack administrative staff in our administrative office to be able to administer the entire agency. We don't have a formal training division, which is relatively unusual for public defender systems. We also lack basic infrastructure and frequently struggle to afford basics like servers and phone equipment and computer equipment and legal resources. We still operate our assigned counsel program on a paper voucher system, and we don't have a modern case management system, all due to a lack of funding for these items. Now I've told you all the bad stuff. The question is, where do we go from here? And one of the things that prompted these conversations that we're having this year is that last year during our conversations with our budget committees, they expressed some frustration because I think they felt like in the past we had come to them with requests to essentially band-aid the problem and not really address the fundamental underlying issues. And so as part of our budget language, they asked us to create both a review of what our problems were and to also create a solution that was no longer band-aiding the situation, but would lead to sort of the fundamental changes that we needed in order to move forward. And that ended up becoming the staffing report that we did on the status of public defense, along with the 3-phase plan to fix public defense that we submitted to the Legislative Budget Committee last September. That report I forwarded to the committee. Hopefully that link is included in your information, but even if it's not, you can go to our webpage at sbids.org, and it's on the front page with a link to it as well. So you can read through it, and it's very long, so it'll give you a nice weekend's worth of reading with all of the basics as to how we got to what we got to. But the gist of that is that we recognized that in order for us to fix this, we're going to have a commitment from all of our stakeholders in the public, in the criminal justice system, our prosecutors, our judges, the governor, and the legislature, in order to commit to investing in our system, because investing in our system does have a variety of benefits, including creating the structure to help our attorneys meet their ethical obligations and to ensure that we are following best practices and doing so in the most cost-effective manner. So to that end, one of the things that I wanted to talk to you a little bit about before I get into some of the details of our budget requests that we're making for this year is to talk about holistic defense. One of the first things we have to do is really shore up our foundations. But shoring up the foundations without having a good vision of where it is that we want to go with this is not really all that helpful. So our question was, where do we want to end up down the road? And one of the things that we've discovered in having extensive conversations with a lot of other public defender systems in the state or the United States, across the United States, has been that there is definitely a movement towards accepting what's called holistic defense models of defense. And for those of you who are not particularly familiar with this, I mean, I can go into great detail about this if you want me to, but holistic defense is essentially a recognition that our cases are not being conducted in a bubble. Essentially, that our clients come to the criminal justice system often with a myriad of other issues that then complicates their ability to get the appropriate outcomes in their cases, and then also leads to additional contacts with the legal system down the line, which leads to additional costs for the state and leads to additional problems for our clients. And holistic defense is essentially an interdisciplinary model to use both legal and non-legal services to meet our clients where they are in a way that is both cost-effective and provides better representation for our clients. And one of the things that I wanted to talk about is that I know that anecdotally, if you talk to any public defense professionals, they will tell you that this works, that they know this works. But for a long time, we didn't have a lot of feedback about whether or not financially that actually works. But the Rand Corporation and the University of Pennsylvania School of Law recently conducted a 10-year study of holistic defense practices in the Bronx. And what they found there after that 10-year study was that the holistic defense practices compared to traditional defense that essentially only treats the case as is immediately in front of you, was able to prevent more than 1 million days of incarceration. They were able to reduce the likelihood of a prison sentence by 16%. They were able to reduce the actual prison sentence lengths by 24%. And they were able to save taxpayers in New York an estimated $160 million in inmate housing costs. And in spite of higher pre- and post-trial release rates, 10 years after case resolution, they determined that people who received holistic representation committed no more crimes than those who were incarcerated for longer periods of time. So in other words, the finding was that holistic defense has been statistically proven to reduce incarceration rates and save taxpayers money without harming public safety. And that's one of the reasons why public defense systems from New York to Kentucky and Texas have all embraced this concept of holistic defense, because it's a better use of resources, it's able to produce better outcomes in the end, and it ends up still being able to do that while being able to protect public safety. And so that's ultimately where we're interested in going with this after we shore up our foundations. There is no way to sugarcoat the fact that Kansas is going to have to spend more money on its public defense system in order to meet its obligations under the Sixth Amendment. I mean, the statistics that I told you up front about our average hours per case are just unacceptable. And the question is, how can we invest that money in our system in a way that gives us the biggest bang for the state's buck? And that's one of the reasons why we're focused on first shoring up our infrastructure and then moving to a more holistic defense model as we move towards the future. And so to that end, BIDS has made several budget requests that start with the fiscal year 2022 to begin addressing some of our most immediate and most dire needs. And those budget requests are the first phase in our 3-phase plan that we've developed in order to shore up our crumbling infrastructure. and begin that transition. And those budget requests include enhancement requests for $7.9 million for staff adjustments to address our ethically concerning caseloads. What that gets us is 26 new public defender positions, 15 additional legal assistants, 35 additional investigators, and 13 additional administrative assistants, as well as 6 additional administrative staff. We've asked for $4 million for attorney and support staff pay parity compensation adjustments, and $164,000 for a bids training division and associated costs for that. $3.5 million for an increase in our statutory rate from $80 to $100 an hour as the first phase in a 3-phase plan to increase our assigned counsel rate, and around $350,000 for basic infrastructure needs, including IT security items and a modern case management system. But we also understand that if we're going to ask for that kind of an investment, that obviously we need to be able to report back on our progress and the impact that that investment is going to have on the criminal legal system as a whole and on our agency. And so we've created 10 success metrics that include a variety of things that go to both the cost effectiveness of the system as well as to the quality of representation. Those include keeping track of success metrics that we can report back to the legislature year after year, including the number of days that public defenders refuse new cases, the rates of the increase in assigned counsel case numbers, talking more in detail about our caseload as we've done in our report already, looking at turnover rates, looking at the hours invested per case, and a concept called time saved, where we look at what the savings is with avoiding prison time between what original charges were and what our ultimate outcomes are in individual cases, the cost of lost experience when we do have turnover, the cost per case, which is something we already report on, but we can do that in more detail, and continuing to have regular employee impact surveys as well as training and reporting on those issues to the legislature as well. Some of these are success metrics that will show immediate improvement. Some of them will be a little bit more long-term in order to see the outcome. But, you know, we're intending to be in this for the long game and have a cost savings for the entire system when we get done. The chronic underfunding of public defense in Kansas, as I said, is not just a bids problem, it's a criminal legal system problem. And that's one of the reasons why, you know, that statistics that I brought up at the beginning, that 85% of our adult felony cases in Kansas require appointed counsel matters, because, you know, the underfunding creates problems for defense counsel, defense clients, it creates problems for prosecutors, for victims, for police, and the courts, and they all suffer at the expensive consequences of that. Right now, that public defense system is not functioning. And so our hope is that with the budget requests that we're making, with this informational presentations that we're trying to do to help educate people about what the problems are in our system, and with the idea that we could eventually move towards this holistic defense program in a way that will eventually result in some cost savings down the road, that we will be able to solve those problems in a fundamental manner, and at the end of the day, be able to provide appropriate support for our public defenders and our assigned counsel and our clients. So I very much appreciate the time that you have let me come and spend with you. I know that you don't have a lot of it, and I am more than happy to answer whatever questions you might have about the presentation today.
Very good. Well, I know we've got at least a couple. First up is Representative Wheeler.
Thank you, Mr. Chair, and thank you, Heather, for your excellent presentation. I have a comment. Maybe it's a question. I recall sometime back around 2005 in the Public Defender's Office in Garden City, Kansas, the staff and the lawyers were buying their own toilet paper. Mm-hmm. How long has this crisis been going on?
For decades. And I will say, I do think that that is in part a problem on our part for not bringing this issue to the legislature's attention, the severity of it to the legislature's attention in as stark of detail as we have this time. I personally am of the opinion that it doesn't do us any good to pretend like our problems aren't our problems. But I know that that has not always necessarily been how this was approached before I came on. So I know before I became the executive director, I spent 16 years in the agency as an appellate public defender. And there were regularly times where we literally had to go out and buy our own paper in order to print our appellate briefs on, because we didn't have enough paper to last us to the end of the year. And that was not uncommon. So, I mean, these are problems that have been fundamental for a long period of time. And frankly, they're just going to keep getting more expensive to solve.
May I, Mr. Chair? You mentioned holistic defense. And pardon me for relying upon lips to hear. Sounds a lot like drug courts, veterans courts, other types of courts. Is that kind of what you're referring to?
It certainly plays into that process. I mean, that's definitely the way that the courts have been moving towards, only this would be focused on the front end of that system with the public defenders themselves and their office and their support staff being involved earlier on, as opposed to waiting for that process to play out. And the additional process of this would be that it would be a statewide program. I mean, obviously there are some counties that offer drug courts and some that don't, some that offer veterans courts or mental health courts that don't, and others that don't. So this would be definitely a much more consistent across the board opportunity for our offices.
Do you mean you're going to get somebody into drug treatment, or what are you going to be doing up front?
A lot of it is going to be identifying some like literally fundamental problems. I mean, just things like being able to get to court on time, or having the ability to have, you know, if you've got child care issues, in order to be able to make your hearing on a particular day, those sorts of things. I mean, like a lot of it is just some of the fundamental stuff. It does go into things like being able to early on assess and address what kind of mental health or drug treatment needs there may be, and being able to expand the scope of what we're doing to address those issues early on. It certainly plays into what the courts are already doing.
Would this, in your opinion, require amendment of the criminal procedure code and the criminal code?
No, I don't think so. It's more a matter of funding for the positions in the office to be able to do the legwork. I think it would correspond with what's already there and what the courts are already doing.
One more, Mr. Chair. You've really explained the caseload problem for lawyers in your staff. I mean, those are high numbers.
Mm-hmm.
I would like to know if you are able to tell me how frequently you have some of your lawyers cited for ethics for not adequately representing their client because of their overload. Are there ethics complaints filed?
Yes. Now, I will say this, and that is that ethics complaints when you're a criminal defense attorney are pretty common regardless. And so one of the difficulties that we have is, when we're notified of an ethics complaint, I mean, we have an obligation to see what the underlying issue is, and if it's something that we need to address. I certainly have seen ethics complaints that I felt like were probably a problem more of our system as opposed to the individual attorney's individual failure.
Not sure I understood that. Does that mean the numbers are resulting because they can't adequately? I mean, you told how many hours need to be spent on various types of cases.
Yeah. I would say the ones that I've seen come across, I don't know that we've got an outcome on those yet. But like I said, I think my concern is that I've seen the ones that I've seen, and they are obviously a symptom of our system and not of an attorney's individual failing.
I understand that.
Yeah.
Thank you, Heather. Thank you, Mr. Chair.
Representative Carmichael.
Thank you, Mr. Chairman. I greatly appreciate Representative Wheeler's insightful questions. Ms. Cessna, I think you indicated that at present, private counsel is working for $80 an hour. Is that what you said?
Yes, that is the statutory rate.
I think bids started in about 1982, if I recall. And in 1982, I was charging $80 an hour for my services 40 years ago. How in the world do you find any private? I don't know of any lawyer other than people working for bids who'd work for $140 an hour in today's world. How do you find these people?
Well, I mean, I'll be real honest. I mean, we have been very much the benefit of the fact that I think the local bars understand the need for the service, but they are somewhat limited in the fact that if they're going to take that much of a loss on each individual case, there's only so many cases they can volunteer to take. And that's ultimately one of the problems that we have is when we have, for instance, I'll use our Sedgwick County office as an example, because I know that's where Representative Carmichael's from. But our Sedgwick County Public Defender's Office, because of severely high caseloads and because of severe turnover, partially because of those high caseloads, we recently had to shut down and refuse cases. We were still working the cases that we had, but we had to stop accepting new cases in Sedgwick County for almost 5.5 months. All of those cases during that time then were being put off onto our assigned counsel, where our assigned counsel also have to control their own caseloads. And so what was happening in that situation was our assigned counsel were refusing cases or entirely removing themselves from the panel altogether because they couldn't take any more cases, and our public defenders weren't able to take cases either. And the thing you have to remember about Sedgwick County is Sedgwick County is a very large jurisdiction. We have an extensive assigned counsel program there. We also have a main public defender, a conflicts public defender, backup contract counsel, and an assigned counsel program there before those cases ultimately end up on the assigned counsel program. And we still were exhausting them because of.
I think don't you also have capital defenders who on occasion take less than capital cases?
We do on occasion if we need some help with overload, although again, because of their own capital cases, they're kind of limited in what they can and cannot take because of their own caseloads. So they do step in and occasionally help us, but that's been pretty limited help given the number of cases that we're talking about.
Yeah, I think my friends who are doing capital defense, I can't recall them doing a non-capital jury trial in quite some time. So I think that's consistent with that. We heard from Mark Bennett, the district attorney in Sedgwick County, I think it was last week, and I cannot remember how many thousand cases he estimates are backlogged right now because of the COVID crisis, the unavailability of juries and courtrooms to move the docket. What in the world are you going to do when thousands of cases that have been backlogged in the system now face a speedy trial requirement? How are those people going to be defended?
The short answer to that is I don't know. I mean, part of the reason why we have been able to keep our head above water at all this year has been in part because of the slowdown in the courts, but that's not good for our clients and for their speedy trial rights. And because we've been losing, counsel off of our assigned counsel programs, that's definitely going to be a problem if we are in a position where we have to push to get through a bunch of cases in a particularly short amount of time. So the short answer to that question is I don't know. The long answer is that at some point, somewhere, there's going to be a judge who's not going to have a defense attorney to assign to that case. And that's going to be problematic for our whole system.
Another aspect that concerns me is the professional career development of public defenders. It's been at least a tradition to my observation that young prosecutors work their way up in the prosecutor's office. They then become a assistant, chief assistant, a deputy, and then they ascend to the bench. Our recent experience with federal public defenders has been, unfortunately, the opposite, that they're nominated and then they're rejected by our colleagues in the Senate. Does that have any impact on people whose career is in this field and want to progress up the chairs, so to speak, in the profession?
Absolutely. I actually submitted testimony specifically addressing that issue with the Senate Judiciary Committee because I've heard people in our agency say that if they have any desire to be a judge, they know they have to essentially wash the public defender off themselves first, which that obviously is problematic because we should value the Sixth Amendment in our criminal justice system, of which public defenders are obviously an important part. But second of all, obviously that creates real issues for our ability to recruit and retain people who have any desires to have other career options after being a public defender.
Well, it also causes me concern, Ms. Cessna, because we all know that when a lawyer assumes the bench and puts on the black robe, that they leave their prior experiences and biases behind and become a neutral judge and fact finder. But the perception of a criminal defendant when he or she appears in front of someone who's fresh out of the prosecutor's office. In fact, years ago, we had a saying that a particular judge was the DA's Annex on 6, referring to a prosecutor who had matriculated to the bench and was known to be a very stern man. And so I think from the perception of justice for defendants, it's not a good idea if the career track is prosecutor, judge, court of appeals, because the appearance to the defendant is that they're being railroaded. Is that a valid concern?
I think, I think that if we're going to assume that somebody who comes from a prosecutorial background is able to put their inherent biases from their previous experience aside, that should equally apply for somebody from the public defense background, whether that's a public defender or assigned counsel.
I certainly agree. And finally, Mr. Chairman, my last, question or comment is I learned just last week that another one of your senior public defenders and a former constituent, a good friend of mine, he's off to Kansas City. He says he's had enough of it. And it seems to me that when I talk to my friends in the prosecutor's office, in public defender's offices, either they've left or they're getting ready to leave. And it's a bad situation. Thank you, Mr. Chairman.
Any other questions? Representative Humphreys?
Thank you, Mr. Chairman. Just super quick question. Can you tell me the statute of the $80, the statute number?
Ooh, I should know that off the top of my head, and I honestly do not, but I can definitely follow up and give that to you when I, get back to my office either tonight or tomorrow morning.
Okay, that'd be great.
Yeah.
Thank you.
All the things I do know off the top of my head, that's when I should. Yeah. No, that's fine. I'll definitely follow up.
Representative Jennings?
Thank you. We're not a budget committee. Thank you for being here. I'm just going through the written testimony that you submitted, and at least to this point, I've gotten up to about $30 million, which I think gets us through phase 1 and phase 2. And then there seems to be some add-ons beyond that, interns and the like that maybe were not included in that first calculation. And good for you. I mean, you have to ask for what you have to ask for. I'm curious, though. District judges in this state are paid $130,000 a year. It looks like appointed counsel other than bids employees are paid $80 an hour times 2,080 hours a year is $166,000 a year. Granted, they have some overhead and self-employment tax to pay and the like, but it looks to me like not only does your part of this justice system have a problem, it strikes me that maybe trial court judges at $130,000 a year looks to me like they're pretty substantially underpaid as well. Is this a systemic thing with judicial branch kinds of issues, or what are your thoughts?
It is a systemic problem, I think. One of the things I will point out is that our starting salary is $55,683. So that gives you an idea when somebody's coming out of law school and they have hundreds of thousands of dollars worth of debt from undergrad and from law school. $55,683 is problematic for most people to even start in a public defender position to begin with, unless they've got family help or a spouse or something like that that can essentially help them pay their loans. I do think that this is a general systemic problem with our criminal legal system, that we have underfunded it or funded it on the cheap for a long period of time. And the problem is that you let those things go for a long period of time and they just become more and more expensive to fix, which I know we all know. And I'm not suggesting necessarily that, I don't want to necessarily compete, although I know realistically we kind of are, for the same tax dollars as, Justice Lukert when she comes before the committee, budget committees, and asks for funding for the court. But I think particularly public defense has been very much left behind out of those conversations, in part because we haven't done a very good job of advocating for ourselves, but also because, frankly, we're very unpopular. And so I think, but if you understand the necessity, you can't have court cases moving along if you don't have the public defender standing there or a public defense assigned attorney standing there when you're talking about 85% of the criminal cases in Kansas. So we're fundamental to that ability for the courts to function, and it's definitely part of that systematic problem.
Representative Humphreys, thanks to our outstanding research staff listening in, and now Joe Molina. It's 22:45:07.
Yes, thank you.
Yep. It's a great thing about being online. People can answer our questions. Back to Representative Wheeler.
Thank you, Mr. Chair, and thank you again. Back in December of 1975, when I started practicing law in Garden City, our one district court judge, wasn't called chief judge, said that if you signed the book anywhere in the 25th Judicial District, you took court appointments. I don't think it's that way anymore, though, is it?
I don't believe so. And honestly, I think part of that is a function of the fact that over the years since then, criminal defense in particular, criminal law in general, has definitely become a much more sort of specialized area of law in a way that it wasn't, 40, 50 years ago.
Actually, it was. It's just that a lot of people didn't know it.
Well, that's probably true.
But the second thing is, in reference to the 2080 times 80, my recollection is that there was a limit on every case to which could be paid. Does that still exist?
Yes, we do have caseload, but we have caps on our assigned counsel program. However, there is the out to that, which is the exceptional orders, and we are getting massive numbers of exceptional orders signed by judges overriding those caps, in part because our caps are kept artificially low because of that $80 an hour, and it's just not realistic. And so they're validly concerned that people are not getting paid for the work that they're doing, and they're signing those exceptional orders. And when the exceptional orders are signed, we pay what the exceptional orders are after we've done our internal audits.
Years ago, I had experience in that too, just one time, however. Thank you very much.
Any other questions? Let me check online one more time. Do not see any. Thank you for coming over.
Thank you very much for having me.
Absolutely. Committee, we have one hearing today. I'm going to open the hearing on House Bill 2127, and we will have Natalie let us know what this bill's about.
Thank you, Mr. Chairman. House Bill 2127 would require the Department for Children and Families to release information to the public related to a child fatality caused by abuse or neglect when criminal charges are filed related to the fatality. So the bill amends KSA 38-2212. Current law there provides that in the event that child abuse or neglect results in a child fatality, the Secretary for Children and Families is required to release certain information in response to an open records request within 7 business days. This bill would add that if criminal charges are filed against a person related to that fatality, then the Secretary would again be required to release that listed information in the same manner. And I can take any questions.
Sorry, any questions for Natalie? Representative Wheeler?
Thank you, Mr. Chair. Natalie, just to make sure I understand, if criminal charges are filed under this new bill, there will be no release of information until such time as an open records request is filed, or is it just generally released?
Mr. Chairman, there are some other statutes about their records release, but in this instance, what we're talking about is when that information can be released pursuant to this statute. So right now, the only trigger for that happening is when the department kind of determines that the fatality was as a result of abuse or neglect. But this would allow, even if maybe DCF hasn't finished their investigation of that, if criminal charges are filed, then that information could be released.
Any other questions for Natalie? Okay, if not, we'll move on to proponents. And our first one up is Secretary Howard on WebEx.
Thank you, Mr. Chairman. I appreciate the chance to be here today in front of the committee. And I come here today in support of House Bill 2127. This is a bill that was requested by DCF. And from my perspective, this is really legislation about continuing to expand transparency. I really believe that transparency and accountability are essential to the work that's done within all of government. But I think nowhere is that probably more true than in the area of the child welfare system. So I requested this bill because I believe it will be another important step towards increasing transparency. As your staff indicated, what this bill would do is provide an additional criteria under which DCF could release summary information to the public when abuse or neglect has led to a child death. The current statute is sometimes very confusing to the media and the public. It requires that DCF complete its investigation before it can release even this summary information to the public. So we're asking that the statute be amended to add language that would allow, actually require us to release that summary information upon the filing of criminal charges against an alleged perpetrator in the event of a child fatality due to abuse or neglect, even if we as an agency have not concluded our investigation. A little context and history might be helpful here. The provision that we're talking about amending is a pretty new statutory provision. Some of you may recall when this was added into Kansas statutes. There was a really terrible child fatality a few years ago, the Adrian Jones case, and I think many of you on the committee may be familiar with that circumstance. And so as a result of, I think, just really a lot of concerns and frustration about the lack of information that was being made available to the public, the legislature passed this legislation. So what this section of statute does is dictate what information can be released in the event of a child fatality from child abuse or neglect, and the circumstances when it can be released. What's released as a result of this statute, maybe going back to an earlier question, is really a summary information. Under this particular statutory provision, the DCF would be releasing, upon an open records request, the age and sex of the child, the date of the fatality, some summary information about whether or not DCF has had involvement with that child, and the findings of any reports that we received, and any services that were provided to the child. As the statute is written today, it ties that release to DCF having concluded its investigations. Sometimes in these circumstances, DCF and law enforcement are, really working side by side jointly on that investigation. And so things happen, very much in sync. Sometimes DCF steps back and law enforcement proceeds with their work. And so in some circumstances, criminal charges could be filed before DCF has actually, through its social workers and investigators, made its own finding of abuse or neglect. So current law, even if criminal charges have been filed, would not allow us to release this summary. This bill would add language that would say, or criminal charges are filed against a person in relation to a fatality. So again, it would expand that. What really led me to request this specific legislation was a death of a child last summer in Wyandotte County, a young child named Olivia Jansen. This was a circumstance where DCF stepped back and law enforcement proceeded with their investigation. Their investigation proceeded quickly. Their district attorney acted very quickly to file charges Yet DCF still had quite a bit of work to do to make its own findings, interviews to do, records to review. And so the perception from the media and the public was that we were trying to hide something. Nothing could have been further from the truth. I desired nothing more than to release this summary of information about the agency involvement. So what this amendment would do would simply, again, allow, in the event that criminal charges were filed, that we as an agency under this statute would then, upon an open records request, be required to release information on the child's age and sex, the date of the fatality, our involvement through any previous reports made about the child, and any services that we as an agency have recommended. So I strongly support this legislation. I think it's an important part, as I said, of increasing transparency, and I think, frankly, building trust with the public. And I think that's a really, really important value. Child fatalities are serious incidents that communities grapple with, and it's important that the public has access to this information, as House Bill 2127 addresses. I'd be happy to stand for any questions.
Thank you. Representative Heiberger.
Here, I have a revisor question at the appropriate time. Now appropriate?
Now's appropriate. Natalie's ready.
Okay, Natalie. I'm wrestling with the language here, Natalie. I mean, I'm trying to see how this differentiates from what's already on the book. So in order, I mean, to determine whether, well, if DCF hasn't made a determination of child abuse or neglect, then we can't tell whether this is such a fatality. So would the charge referred to here have to be a charge of child abuse or child neglect for this to add extra protection? My question makes sense?
Mr. Chairman, I think it does make sense. And that is that language, the criminal charges are filed against a person in relation to such fatality. That's an attempt, I think, to describe that it could be any type of charges. It could be some type of murder charge, but it could be some lesser charge as well. And so that was used to kind of make that broad so that it could be any of those criminal charges filed that were related to the fatality.
But if DCF hasn't made their determination of child abuse or neglect and the charge isn't child abuse or neglect, how do we know it's a result of child abuse or neglect? I guess is my question.
Well, so I think Secretary Howard can correct me if I'm wrong, but I think the idea is that maybe DCF is still in the middle of their investigation to determine exactly whether the abuse or neglect led to that fatality. But then in the meantime, criminal charges, were related or were made against someone that had something to do with that fatality. Maybe the charges aren't abuse and neglect charges. Maybe they're murder charges. And so that then would allow the secretary to release that information, even if they haven't determined that abuse and neglect actually caused the child fatality.
Yeah, so that's my last comment on this. Okay, if the fact that they haven't determined that child abuse or neglect has resulted and that prevents them from releasing information under this section, would that not apply to, how do we know it's such a fatality or such a, you see what I'm getting at? I mean, if the section the way it's written now prevents them from releasing the information because they haven't made a determination of child abuse or neglect yet, and the charge that we're talking about isn't a charge of child abuse or neglect, how do we know that how do we know that this is such a fatality as referred to in line 27?
I see. So I think what you're saying is you're tying the in the event that child abuse or neglect results in the fatality to the criminal charges. And I think
I'm tying it to such fatality. Again, this is probably an out of committee
I
discussion.
see. So you're suggesting that perhaps like that use of such fatality implies that DCF has to have already made their finding. I wonder if that could be, I mean, we could just say in relation to a child fatality. Is that kind of what you're getting at?
Representative Carmichael.
Thank you, Mr. Chairman. I want to look in more detail at what Representative Heiberger was just addressing, because I recall now 4 or 5 years ago, at the time we passed the current version of the statute, then Chairman Finch and I thought we had fixed this problem, and we hadn't. But the difference, Ms. Howard, is that under the prior administration, it was a battle between the members of this committee and the lawyers in protective services and at DCF, which is part of the same thing, to try to accomplish our purpose. We obviously didn't get it done. So I appreciate you coming to us today with a proactive proposal to try to accomplish what, frankly, I thought we had done several years ago. So I want to express my appreciation. And yes, I did give you a hard time last summer when you didn't release the information. I understand your legal basis for it, but I'm certain that the lawyers at DCF would be happy to work with Representative Heiberger and anybody else on this committee to try to get it right this time. Am I fair in that presumption?
Yes, that's correct. I mean, we're certainly happy to work further with members of the committee or with the revisor. Obviously, our clear intention is to make sure that there aren't situations such as the incident last summer where we're not able to release information when criminal charges have already been filed, and we don't have just really undue delay in making sure what I think is important summary information be available to the public.
Well, I greatly appreciate your cooperation in that regard, and I think we can probably work together to make sure that we accomplish our purpose this time around. But this does not necessarily mean, however, that all of the agency's records concerning the child involved are going to be released within 7 days of the filing of charges, correct?
You know, that's correct, Representative. This is the provision of law that just requires the agency to release this summary information. You know, further up within the same sections of law, actually F1 and F2 of the same statute, are the provisions that speak more directly to the release of the actual records. And that's a far more extensive process that requires notice being given to involved parties. It involves an opportunity for individuals or entities, could be an individual involved, could be law enforcement, asking the court not to disclose those records, and the court making findings on whether or not to close those records. And you know, and really, I think that part of the impetus for passing this statute in the first place, for us to provide a summary, is that in many cases, courts do make those decisions to close those records while law enforcement is pending or while court processes are pending. You know, and so the addition of these provisions a few years ago that at least has us as an agency provide basic information about our prior involvement with the family, I think really was an attempt at transparency and public trust.
And Madam Secretary, I also recognize that you're subject to some federal privacy requirements as well, and you obviously have to comply with those rules no matter, I hate to put it this way, but no matter what the Kansas legislature does.
That's correct.
Well, and I don't mean to be critical at all that not everything is going to be released in 7 days. I think it was our intent a few years ago to at least get notice out there that the child involved had been in DCF custody, or there had been DCF involvement of one kind or another, so that the press and other concerned people could try to avail themselves of the provisions of the law to obtain more details about the circumstance, because without the summary information, there was no information at all. And so I appreciate what you're doing here, and I certainly support the legislation, and I'll try to work with whomever we need to make sure we get it right this time. Thank you, Mr. Chairman.
Any other questions for the secretary? Do not see any. Thank you for joining us today.
Thank you.
Committee, you've been emailed proponent testimony from Foster Adopt Connect and Children's Alliance of Kansas. Is there anyone else as a proponent? Don't see anyone as a neutral. Don't see that either. What about opponents? None. I'm going to close the hearing on House Bill 2127. Committee, I think we were streaming, but in the event we weren't, just to confirm, at the beginning, we had 3 bills that we agreed to introduce. RS 0853 on behalf of the Judicial Branch, RS 0041 on behalf of the KBI, and RS 0657 on behalf of Amazon. Anything else, committee? Don't see anything else, so we're going to call it a day. We'll see you all tomorrow. Thank you. Our meeting's adjourned.